I'm not going to use the victim's name because we have media here, but I know the victim has an active social media account, and you've been told not to live stream or otherwise record this. Is that correct, ma'am?
Yes, that's correct.
And you are not recording or live streaming or taking any video of this as feed. Is that accurate?
Absolutely not.
All right. That is accurate, what I said, or not?
That's accurate.
All right, thank you.
That's accurate. I'm not recording.
All right, thank you. Ms. Grimshad, you may call the case.
Thank you. This is case number 2024-47077-FC. People of the state of Michigan versus Greg DuJardine. People represented by Britta Grimshad. Defendant is present at his counsel table in the custody of the Ottawa County Jail. His attorney, Anna White, is present on his behalf. The matter is up today for sentencing. I have had an opportunity to review the PSI report. Obviously, we discussed that report in chambers, and there are some corrections related to the substance of the report and then the scoring of some of the OBs and PRVs that need to be put on the record.
Some of the changes to the substantive issues are relatively minor.
Sure.
For instance, the first name of the defendant is Greg, not Gregory, so those changes have been made. On DuJardine, the J has to be capitalized. His high school completion has been recorded correctly, and one of the prior offense variables indicated that it was, one of the prior convictions indicated that it was a plea back in 88 or 86, and that actually was a jury trial. So we've made those corrections. In addition, we've also looked at the prior records as it pertains to misdemeanors, and the 1986 PSI revealed several misdemeanors, 3 of which are scorable. And those are on page 4 of the 1986 PSI. And frankly, they probably predate some of the computer systems. So again, they were put on the 86 PSI. The defendant was questioned about them back then. He indicated he was represented by counsel. So the DOC, Ms. Sitzer, is going to, unless there's an objection here, record those prior misdemeanors, some of which are not scorable. Nevertheless, they are misdemeanors. And then 3 of which are scorable. The first one, there was an MDOP, illegal entry, and there was an OWI back in the early 80s. So that's where we landed on that, which would affect PRV 5, puts them at 3 misdemeanors. And at this point in time, we've got them at 75 points on the PRVs, which is a level F. So that's the PRVs. Is that correct, Ms. Grimshad?
That is what I have now as well.
Is that correct, Ms. White?
It is.
Since we're talking about prior record, we also need to verify that the supplements are resolved. And Ms. Grimshad, you have the information in front of you.
I have the second page with the supplements.
Could you bring it up here, sir? So for purposes of the habitual offenders notices, Ms. White, are you conceding that on or about August 31, 1981, your client was convicted of attempted receiving and concealing stolen property in the 20th Circuit Court, which is a felony?
That's correct.
And that on or about September 2 of 1986, he was convicted of CSC second in violation of statute in the 20th Circuit Court for Ottawa County?
That's correct.
And finally, that he was convicted of CSC first in the 20th Circuit Court in Ottawa County on or about September 18, 1989, is that correct?
That is correct.
So the habituals are not being challenged, is that correct?
That is correct, Your Honor.
And in addition, because of the last offense that I mentioned, the CSC first, and he's charged with habitual fourth, that requires a mandatory minimum of 25 years. Would you agree with that, Ms. White?
I agree with that, Your Honor.
Do you agree with that, Ms. Grimshad?
I do.
All right, so any objection, Ms. White, as far as the establishment of the habitual offender notice?
No objection to that.
All right, OVs. You may proceed.
Would you like me to proceed with that, Your Honor? Thank you. Looking at the pre-sentence investigation report that was completed, we have a couple objections. I believe OV 3 was scored at 5 points. We had some conversation in chambers about the fact that because bodily injury was a element of the offense that is not scorable, that should be 0. OV 4 was scored at 0. I believe that's correctly scored at 0, but I understand Ms. Grimshad has an argument to make about that.
Ms. Grimshad, OV 3 is at 0?
I do believe, based on the way OB3 is worded, that because bodily injury was a component of this offense, CSC second, that it should not be scored.
All right, and what's your position on OV4?
OB4 deals with psychological injury to the victim of this offense. based on the testimony that came out during the trial, I think there is sufficient evidence to show that she did in fact suffer psychological injury. She indicated it impacted her ability to sleep, her ability to go outside, that she was fearful, and that she is in the process of seeking counseling.
Any rebuttal?
Yes, Your Honor. We would object to the scoring of OV4. We understand that during the trial on direct examination, the victim did state that she had some impacts on her life. However, I believe on cross-examination and due to some other outside activity that she'd engaged in, I think that was shown not to be completely accurate, and so I would object to the scoring.
Well, two things can be true at the same time. She can suffer psychological injury while still engaging in some aspects of her normal life. While the PSI itself may not support OV4 scoring, the trial testimony itself does. I made notes during the trial, and I believe that has been satisfied by a preponderance of the evidence. Next issue.
Thank you, Your Honor. In the PSI, OV10 was also scored at 15. I wanted to put on the record an objection to that OV as well. I know that we had some conversation again in chambers about that. I can place my objection first if that's helpful.
All right, go ahead.
Thank you. OV10 is in relation to a vulnerable victim. I understand that we had some conversation about case law there and that predatory conduct does not involve the victim being considered vulnerable. I would just dispute the acts that happened prior to the alleged incident here being predatory. I think there was an argument, and Mr. DuJardine did testify at trial about what happened prior to the incident happening, and I think that hasn't been proven by preponderance of the evidence that it was predatory conduct prior to the incident.
I respectfully disagree. I do believe that OV10 is appropriately scored at 15 points, reflecting that the defendant committed predatory conduct during this offense. You had testimony at the trial that he followed the victim in her car for upwards of 7 miles, that at one of the intersections he rear-ended her lightly, that appeared to be a ruse to get her to pull over. And while she may not have been his intended victim, he was seeking a victim in that conduct.
Thank you. The court is looking at People versus Houston, Huston, 49 Mich 451 at page 463. And they state predatory conduct under the statute is behavior that is predatory in nature, precedes the offense, and is directed at a person for the primary source of causing that person to suffer from injurious action. And in this case, the Houston case, a person basically delayed in wait for somebody to rob. It's, by analogy, it's pretty similar here. He was lying in wait at Duncan's Woods, found the target, and then followed the target. So this squarely fits within the Houston Supreme Court case. It's binding precedent, so the court will score 15 points. Next issue.
Thank you, Your Honor. And I can take them both together. I think OV12 and OV13 were both scored respectively at 5 and 25 points, and I believe those should both be scored at 0.
Ms. Grimshad, do you agree?
I do agree with that.
All right, so I've got him at 25 points for OVs. Is that accurate?
Yes.
Yes, it is.
So he's at an F3, which is 43 to 172 for the minimum, correct?
That's correct, Your Honor.
Ms. Grimshad?
I do believe that is correct.
All right, and you have a victim who wishes to allocute. Is that accurate?
Correct. We would like to present her victim impact statement via Zoom, and then would reserve the right to argue.
So I understand she's ill, so she decided to appear by remote technology today. Is that accurate?
Yes, I was alerted a couple days ago that she
Yeah.
was not feeling good.
Ma'am, were you able to hear the proceedings so far?
Yes, I was.
Is there anything you'd like to say as far as the victim impact statement?
I do have one written.
You may proceed.
Good afternoon. First of all, I want to thank Britta, Detective Hill, and everyone else who took me seriously and fought hard to obtain the justice I deserve, as this incident has significantly impacted my life in various ways. I've explained many times how this assault has made me even more aware of my surroundings and has made me uneasy whenever I'm in public or even home alone because I'm afraid I may be attacked unprovoked. As a result of this assault, I have had to seek therapy because I have been severely affected emotionally. Even with that being said, it's still so hard for me to talk about, so even this step is difficult. To know that this could have happened to someone completely defenseless had they been in the same place at the same time as me breaks my heart. I say all of this to make it clear that I believe Greg DuJardine should receive the maximum sentence related to my assault and how it has affected me. I do not believe a person like this should be trusted to live in society, because how can you live in society without upholding basic respect for those around you? This should never happen again to anyone, and I've gone through this process to ensure that it doesn't. And that's all I have to say.
Thank you very much. Kirk? Ms. Grimscheid, anything else?
Yes, just briefly, we've already gone over what the defendant's guideline range is, and we spent a lot of time talking about OBs and PRVs, and as the court just indicated, his guideline range, per statute is 43 to 172. However, that was kind of all moot because, as you indicated, there is a mandatory minimum of 25 years for this offense based on the defendant's priors and what he is charged with in this offense. We are asking that the court abide by that and sentence the defendant to the Department of Corrections for that amount of time for 25 years. He's 61 years old today. That, by my math, would mean that he would be released when he's 86 years old, or eligible for parole when he's 86 years old, and that's after he has some parole issues to deal with as well. My hope is that at 86 years old, the defendant is not in either a mental state of mind or physical state to commit any other offenses on any women in our community. There's a lot of aggravation in this case that is absent in other cases where we're looking at criminal sexual conduct in the second degree. In this case, you have the defendant who was on parole for not any old offense, but for a sexual offense, a criminal sexual conduct first degree. Not only was he on parole, but he was equipped with a GPS tether. Neither his parole status nor that GPS tether attached to his ankle did anything to deter him from committing the offense on our victim in this case. This marks the third criminal sexual conduct case this defendant has committed against women in our community. He is violent towards women, and his conduct exemplifies a complete and utter lack of self-control. I took the opportunity to pull the transcript of his last sentencing hearing. He was sentenced by Judge James Townsend, who I did not have the privilege of knowing, and whom I understand has passed away since he was on the bench and since he made this transcript. But I don't think I can say it better than that judge did. He said that this defendant is very dangerous to women. He could be termed a predator. That separation from society of this defendant for a very long time is essential, and that there are no controls that can be used other than long-term confinement that would safeguard women from this defendant. Those were his words to this same defendant when he was sentenced back in September of 1989. And yet, here we are again. Anything less than a lengthy incarceration puts half our population, female, in this county in jeopardy. He should not be released from prison. My hope is that with the 25-year sentence, mandatory minimum here, and with parole being in place and their ramifications for that violation, that he will not leave the Michigan Department of Corrections breathing. Thank you.
Thank you. Ms. White, you and your client may sit or stand at the table, whatever you're comfortable with, and address the court.
We'll stay at the table. If that's
All right, you may
okay.
proceed.
Thank you. You know, the court had the opportunity to hear testimony in this case, not just from the victim here, but also from Mr. DuJardine. And so the court was able to hear Greg's position on what happened on that day. That has not changed. This is a case where I think hearing the comments from Judge Townsend when Greg was in his early 20s getting sentenced, it's really sad sitting where I am in the fact that I have a luxury that nobody else in this room or watching this has had, which is getting to know Greg. And I think that we understand the position. We've had a lot of conversations about the recommendation here think Greg understands that, most of his life has been in prison, and he has to deal with that. He has to make the most of that. Does not have a lot of support during prison. He had a lot of family who left him, a lot of friends who left him, obviously, given the situation. And in the last couple weeks, his mom passed away, who was his main support. And I just would ask the court to consider him as a human, and not as someone who has just done a couple of the offenses that we've talked about, but as someone who has spent decades now being in prison and in confinement, and hopes that the rest of his life he'll have the opportunity of at least having a chance to be free again.
Thank you. Mr. DuJardine, have you had an adequate opportunity to read and review the pre-sentence report?
Yes.
Any additions or corrections that you wish to make?
Other than the ones we've already made.
CSC in the second degree is not multivariables, so it's only on CSC in the first degree. I don't know if it makes a difference, but.
The multivariables, that means that there's different ways to get to the aggravating factors. That's what it's referring to.
Right, but that wasn't there when I was sentenced. Then all of a sudden it's there. I was paroled, so.
Ms. Grimscheid, do you have the actual judgment of sentence is this from 86 conviction?
86 conviction.
86, do you have that?
I can bring that up pretty quickly. I don't have a physical copy of it with me.
Right. I know it was introduced as a piece of evidence.
I didn't bring the entire case file with me, so I apologize.
But my recollection of reviewing that piece of evidence is consistent with what Mr. DuJardine said. It simply said criminal sexual conduct second degree. Well, regardless, Ms. Grimscheid, is there any objection to amending offense number, the CSC second offense, to reflect simply CSC in the second degree? That's on the,
I don't have an objection.
all right, we'll make that change. Thank you, Mr. DuJardine. Anything else?
No, Your Honor.
Anything else you'd like to say before sentence is imposed?
Not at this moment.
Thank you.
I was able to pull that up for you if you want to see it.
Okay, it simply says the CSC second on it, doesn't it?
It just says crime, criminal sexual conduct dash second degree.
Yeah, that's fine. Obviously, Mr. DuJardine is the only one who is responsible for these criminal offenses. Nevertheless, we need to recognize the decisions that put him out on the street, the decisions by the parole board that put him out. Also recognizing that executive decisions are often difficult. But we have to recognize that back in 1986, after Mr. DuJardine's first CSC conviction, he was placed on parole. There was a special term and condition of parole that required him to engage in mental health counseling when he was out. When he was out, he didn't follow through. Despite the fact that there was a special condition of parole, the parole board did not revoke his parole or otherwise hold him accountable. Instead, we had victim number 2. And that was a brutal assault. Just an absolutely brutal assault. Simply because he was not required to comply with the terms of parole. In reviewing a lot of materials that were supplied by the Department of Corrections regarding his most recent request for parole in 2024, they reflected significant needs regarding Mr. DuJardine's capacity for stable relationships. There were some concerns about his hostility towards women, general social rejection, impulsivity, sex drive preoccupation, deviant sexual preferences, and cooperation with supervision. So how did the parole board respond to these concerns as they were evaluating parole? They had a significant question or concern because the defendant was approaching the age of 60. I don't know what that has to do with public safety. But apparently they also believe the defendant's representation when he said, and I quote, I will do exactly as they say now, meaning the parole authorities. And if I feel that I was going to reoffend, I would go to the police and ask to be locked up. I never want this to happen again. I understand what I did to the victims. These were subjective comments and obviously ridiculous, but apparently they were believed. After he was paroled, he was required to go through some additional counseling, some sex offender therapy, which he was in the process of when this third rape was committed. In spite of his representations that he would do whatever was required by the authorities, he expressed on at least one occasion that he was upset that he had to go through the sex offender training or class again after his release on parole in May of 2024. He was then affixed with a GPS monitoring system. What did not come out at trial, because the court did not allow this evidence to come in because it was more prejudicial than probative, was the fact that in spite of the monitoring, nobody ever picked up on the fact that Mr. DuJardine was hanging out at beaches, public areas, parks, and on his phone that was searched, hundreds of images of unsuspecting females were found. In spite of all that, he was not called into account by the parole authorities, and now we have a third victim. So was this avoidable? Obviously, Mr. DuJardine is solely responsible for these acts, but there's a failure by the authorities as well, and it's inexcusable. It is the sentence of this court that the defendant be turned over to the Michigan Department of Corrections for a minimum of 300 months and a maximum of 900 months. He is subject to the Sex Offenders Registration Act. He has 0 days credit because he is on parole, and this sentence is consecutive to the time for which he was on parole. He must pay state costs, crime victim costs that are required by statute. This is a final sentence. You have an appeal by right with the Michigan Court of Appeals. You may file the paperwork that you're being provided, and if you wish to have a court-appointed attorney, the court will appoint one to represent you at public expense. You need to fill out that paperwork and return it within 42 days. That is all.